Brian, if we're in a hurry, then why don't we just start?
Oh, sure. Yeah, for our final panel this afternoon, it's my pleasure to introduce to you, to my very right, Professor Wendy Kaplan, who is a clinical associate professor of law at Boston University. Professor David Rossman, who is professor of law at Boston University School of Law and is also the director of the law school's criminal law clinical programs. And finally, Elizabeth Frankel, who is a staff attorney of the Immigrant Child Advocacy Project at the University of Chicago.
Thank you, Brian. Well, we've heard today a lot about ways in which the system that's designed to help children has, in fact, failed them. And I wish that we could buck the trend, but we, Wendy and I, have another example of ways in which public policy, perhaps well-meaning, has had perverse effects. And in particular, we're going to talk about the collateral consequence for children in the juvenile justice system of having they or their families face eviction from public housing. It's a problem that potentially can affect any one of the 2.9 million families that live in federally subsidized housing in this country. Of that 2.9 million families, about 40% have children under the age of 18, and although no one actually has this precise statistics, perhaps as many as 10% of those children in any given year will be arrested. And that poses problems for their families because each and every one of those 2.9 million families has signed a lease that contains a clause mandated by the federal government that states essentially any dangerous criminal activity or any drug use by the tenant or any household member, either on or off the premises, is grounds for eviction. And so you get cases like that of Pearlie Rucker, who was a tenant in the Oakland Housing Authority back in the late 1990s. She was a 63-year-old grandmother who was taking care of her mentally disabled daughter. Her daughter was arrested 3 blocks away from the housing project smoking crack cocaine, and Pearlie Rucker faced eviction as a result. The genesis really of this policy, which came to be called the one-strike policy because that was the name given it by the public official who put it into operation, President Bill Clinton, who I am sure felt the pain for each and every one of the residents of the over 3,300 public housing authorities in the United States. This policy, which declared, as President Clinton said in his 1996 State of the Union address, that one strike, one criminal act by any tenant of public housing was going to be cause for eviction, was really a sign of the times. In the mid-1990s saw American public policy seeking answers to vexing problems with very simple solutions that sought to strip discretion away from the government officials who were charged with policing the policy and sought to cure the problems by banishing the people that we thought were causing the problems. And so we had in criminal sentencing, for example, the 3 strikes and you're out policy that on your 3rd felony, no matter how trivial, imprison people for life. And in the area of crime in public housing authorities, President Clinton went much better than 3 strikes because he gave you only 1 strike, and that would be the end of your days in public housing. Public housing authorities are subtly and not so subtly encouraged to evict tenants whose family members engage in violations of the law because each year the Department of Housing and Urban Development evaluates the performance of every public housing authority, and one of the metrics by which the housing authorities are measured is the number of evictions of tenants for having committed criminal acts. And if you score higher on these metrics, then you qualify for extra money and you qualify for a more relaxed standard of review the following year. So HUD looks at how many families have been evicted. It doesn't actually look at whether the crime rate in your housing authority has gone down from year to year or whether the crime rate in your housing authority is less than in a comparable neighborhood of the city. It just looks at the total number of evictions. And so housing authorities have a monetary stake in being unforgiving and evicting people without giving any thought to the consequences. And the consequences are drastic. The people who live in public housing have an average income of $12,800. If you are put out on the street and that's the amount of money you have every year, There is no place for you to go. And the people who are told by the housing authority that they are going to be put out on the street because of a violation of the law by one of their children really don't have any practical avenue of legal relief, primarily because they don't have access to lawyers. The primary source of lawyers for poor people facing civil problems in this country are lawyers funded by the federally funded Legal Services Corporation. There is a provision in the statute establishing the Legal Services Corporation funding mechanism that prevents legal services lawyers from representing tenants who are being evicted for drug offenses. And many legal service organizations around the country interpret that, I imagine, in order to stay out of trouble, to prevent them from representing any tenant whose family member was involved with drugs and whose family member's behavior is the cause of the eviction. So what happens when family members are told that they have a child who was involved in one of these crimes, they're given this tragic choice. Either they leave the public housing authority. Very few of them actually fight the underlying eviction and go to court, not only because they lack lawyers, but because litigating a case in housing court based on the criminal activity of a child presents real problems for the child's subsequent delinquency case, because if the child testifies in the eviction case, then they've given up their privilege against self-incrimination, and what they say could be used in the delinquency matter. If they don't testify in the eviction case, then the housing court judge would be warranted in drawing an adverse inference. So there's very little percentage in actually fighting, even if you did have a lawyer. So the families are essentially faced with this catch-22. Either the family agrees to leave, and if they leave, then they face a 3-year ban on reapplying to public housing. Plus, they have to find a place to go to. And in many cities, including my own, Boston, the emergency shelters that exist for people without permanent public housing will not take you if you were evicted for drug offenses. So there's no place for you. So you just leave, and you just find a cardboard box, or you sleep in a doorway or under a tree or what have you. Or you make the choice to stay, because housing authorities will often permit the rest of the family to stay if you get rid of the kid. So you kick your kid out, or you make your entire family homeless. So just imagine how this looks from a rational viewpoint of public policy, let's say with respect to juvenile justice. We saw before a model juvenile justice standard for the purpose of the system to develop competencies to enable children to become responsible and productive members of the community. So imagine that was your mandate, and you had a child who was involved in a minor drug offense, and you decided, gee, a great way to develop this kid's competence would be to make him homeless, separate him from his family, and put him out on the street. And by the way, try and place a 14-year-old child in a homeless shelter. Not very easy, because most shelters won't take children over the age of 12 because they're afraid of security issues. So it doesn't take social science research to tell you that if you're trying to create an environment to rehabilitate a child and give a child the support that child needs in order to develop into a responsible member of the community, you don't separate him from his family, or you don't make him homeless and the family homeless. Or consider the policy from the vantage point of crime control. At best, what it does is to take people who are disposed to committing crimes and moving them from one part of your jurisdiction to another, because you're not killing them, you're not banishing them from the United States, you're just making them homeless. And not only are you moving them from one part of the city to another, but you're placing them in an environment where it's much more likely they're going to become increasingly involved in ever more serious crime, because in fact they lack the support system that a home provides. Or even consider the policy from the standpoint of its original intent, which was to make public housing safer. Unfortunately, there are no studies that show that the one-strike eviction policy does what it was designed to do. No one can demonstrate that it in fact results in lower crime rates in public housing authorities. But look specifically at someone who suffers the brunt of the policy, like Pearlie Rucker. Ms. Rucker turned out to be the named plaintiff in the case that brought the policy before the United States Supreme Court. And her argument basically was that it is not rational public policy to interpret this statute to apply to someone like Pearlie Rucker, who even the management of the housing authority agreed had no knowledge of her daughter's drug use, had done nothing to foster her drug use, and no one could point to anything that Ms. Rucker could or should have done to have prevented the drug use. She was, in other words, a perfectly innocent tenant. Nevertheless, in an unanimous opinion by the United States Supreme Court, the court held that not only was the policy rational, but it was in fact designed to lead to the end that Congress intended, because the court said strict liability maximizes deterrence. Now, in one of the other hats I wear, I teach criminal procedure, and those of you who've taken a criminal procedure course might remember a controversy that came to the Supreme Court some years ago about whether the exclusionary rule under the Fourth Amendment, which is designed to deter police misconduct, should be applied when police don't engage in deliberate misbehavior but are negligent. So the argument that was made by people who thought that the exclusionary rule should apply was strict deterrence can be maximized by imposing liability on the police in that case. Oh no, said the Supreme Court, remarkably in an opinion by Chief Justice Rehnquist, who, it would surprise none of you who aren't great fans of consistency, also wrote the Rucker opinion. So what we have is two systems, the juvenile court system and the public housing system, that see many, many people who have a foot in both worlds. The two bureaucracies don't interact very well, and the policies that are designed to secure some ends in one that are perhaps ill-designed have drastic consequences on the other, and create not only tragic choices for the parents with respect to the housing issues they face, but tragic choices for the defense attorneys who have to represent the juveniles in the delinquency process, because very often the effective representation of a child requires an attorney to call upon the support of the parents of that child. But when the parent faces this problem of knowing that unless my child's taken into custody, I will be evicted, or unless perhaps my child is acquitted, I will be evicted, it makes it very difficult for the parent to give the kind of independent, conflict-free support that makes them an appropriate member of the defense team. And if, as a defense attorney, you are faced with that situation, it is a very difficult problem for you to separate out, for example, your 14-year-old client from his parents, because you don't think his parents can give the kind of unbiased advice that they are supposed to. And Wendy's going to talk more about the juvenile court problems that the one-strike eviction policy creates.
I think it's not unusual to say that the one-strike policy wreaks havoc on the juvenile justice system. This is a system that's dedicated to rehabilitation. It relies on cooperation among attorneys, courts, parents, and the juvenile client, him or herself. David and I identified 5 stages of decision point stages in the juvenile justice process where one strike really comes into play. I'll briefly outline those, and then I want to get to our strategies for more hopeful strategies. Like Judge Morey, I want to be able to end on a better note. First stage is intake or diversion, considering that approximately 45% of delinquency matters that come to the attention of the juvenile court may indeed be diverted and avoid adjudicatory process. It varies from jurisdiction to jurisdiction. In Massachusetts, it's clerk magistrates who make the decision, but sometimes the screening process is done by probation officers. In other places, it's done by the DA's office itself. What David and I found was, and frankly, we were really surprised to learn that so many of these personnel, these role players in the justice system really had no knowledge of what the one-strike policy did. Clearly, if a child's going to be diverted from the juvenile justice system, there are often programs the child is directed to. If the family loses their home, the child is going to be ineligible for participation in those programs. Those programs rely on some sort of home status that's stable. The second issue is the detention decision. This is when the delinquency complaint has been processed and the child is brought to court for arraignment. Now, most juvenile courts have a presumption that the child is going to be released in care and custody of the parent. But what happens when the parent is facing eviction? And by the way, it's the arrest that triggers the eviction process. Public Housing Authority people don't care about whether the child is eventually acquitted of the delinquency charge. It's what happens at the front end. So arrest triggers eviction, and that can happen very quickly. And so even if a court wants to release a child in care and custody of a parent, there may be no place for that child to go because it obviously puts the parent in a position of making a decision about taking the child home and being evicted or agreeing to the Public Housing Authority mandates and placing the child somewhere else, or asking the juvenile court to retain the child in a detention facility. The third stage is trial or plea decision. And this one really demonstrates the importance of the role of counsel that Rhea and Lisa were talking about earlier. It's incumbent upon defense counsel to explain to a child what are the legal collateral consequences of a tender of plea. And it's also incumbent upon the court to go through what we refer to as a plea colloquy. I'm just curious, have any of you ever seen a juvenile plea colloquy? Okay. How long do they usually take? Yeah. Right, okay. And in this plea colloquy, basically all the court is trying to do is determine whether the plea is made willingly, freely, and voluntarily. So the child is going to be questioned about the child's understanding of what it is he or she is admitting to. And the court usually goes through a litany of rights that the child is giving up. Fifth Amendment rights, Sixth Amendment right to confrontation, etc. Now, we looked at a lot of plea tender forms from across the country, and not one could we find that talked about homelessness as being a potential consequence. I'm delighted that the ABA is looking at this, and I'm looking forward to the publication of their study. But I can tell you now the most extensive one I saw was from the state of Washington, which did mention federal benefits, like denial of food stamps. But it doesn't say anything about homelessness, about being barred from public housing authorities or Section 8 subsidies. So it's clear that both parents and children may not understand completely what a plea might do in terms of their ability to live somewhere. And when we're talking about pleas, we're talking about two kinds. Basically, we're talking about a plea, perhaps about a charge reduction. So it's obviously in the child's best interest to try to reduce something from a felony to a misdemeanor that may play better with the housing authorities. The other is a sentence recommendation. Here we get a little bumpy too, because as David alluded to, a parent may say it's okay for the kid to plead out. If the kid gets committed to a juvenile facility, we get to stay in the apartment. So those are the kinds of issues that come up at that third stage. The fourth stage is the dispositional decision. We've heard from Aaron Kupchik that incarceration should be the last resort, and as early as 1980s, the IJA-ABA standards indicated that juvenile disposition should be the least restrictive alternative. Considering that in 2007, 56% of adjudicated delinquency matters were children who were placed on probation. Probation supervision means that the child has to have some place to be supervised. There may be curfew conditions, there may be home visits, program participation. There are lots of things that come into play with probation. But if a family is homeless, doesn't have a place, that child has no place to go, it's pretty obvious that supervision by probation department is not going to work. And the last stage we wanted to talk about briefly, and I really am racing through this, Brian, is reentry. In 2009, the figures demonstrate that approximately 100,000 youth were released from physical custody from juvenile correctional authorities. Well, where are those kids going to go if the family has already decided that they would accept the housing authority rules and bar the child permanently from the house? If the child comes on the property, the child can be arrested for trespassing, and we're back in the loop of delinquency or, even worse, adult jurisdiction. I think that Kate and Jessica talked about reintegration services, and clearly we have to think about how we're going to let children who have been evicted from housing reintegrate. In some jurisdictions, there's a certificate of rehabilitation that may be presented to authorities, and perhaps we could suggest that housing authorities accept a certificate of rehabilitation as a way of perhaps unbending and, undoing this very rigid approach that they have to one strike. So that leads me to these quick strategies that we are proposing, quick suggestions. The first is legislative. We should modify the one strike policy. Innocent tenants should be protected, and there should be exceptions for juveniles who are, for whom we believe families and keeping families together is more important. And we understand that we have to balance the protection of the community with the rights of the child. But for rather minimal offenses, we ought to be able to keep kids in their homes with their families. Secondly, we suggest some administrative changes. David mentioned before how the housing authorities have this assessment system where they're rewarded for the number of evictions that they're able to close out in a given year. And we're suggesting that they, instead of that, we should turn it around a little bit and reward them for, first of all, abiding by confidentiality laws with respect to juvenile arrest records and juvenile incidents. And we think they should be rewarded for making efforts to work out agreements whereby children can stay in their homes. We also think that there ought to be guidelines that require the PHA managers to exercise some discretion and to not sort of jump the shark here with respect to these eviction proceedings. In other words, wait until the adjudication process is over before trying to evict a family because of a juvenile's actions. We also think that instead of cabining the confidentiality about juveniles in court and police and the PHA's getting information, that the juvenile court ought to be allowed to communicate with the PHAs, communicate with them about what conditions of release the court has had with respect to children that they release either on detention or on supervision, and the conditions of supervision. I mean, there's an irony here that we're all concerned about confidentiality, but we want that confidentiality, we want those parties to share if it's going to help the child to stay home. And we should also allow children re-entry into these facilities, into PHA property after custody has been done. Thirdly, there should be juvenile justice changes. The system needs changes. People need to understand the consequences of eviction. They need to understand that, and they need to be sensitive to the different needs of both the child and the family and their conflict of interest. Obviously, attorneys have a duty to inform the child about the collateral consequence of eviction because of the juvenile arrest, and to make awareness of the collateral consequences of delinquency on the family's continuing eligibility for public housing. We think juvenile correctional authorities need to partner better with PHAs if children are going to be released from those authorities and are under conditions of release. And lastly, housing court changes. We think there needs to be more communication between housing court attorneys and juvenile defense attorneys so that housing courts can incorporate, in the cases that come to housing court, David indicated that not that many get there because they don't have access to counsel. But for those who do, and in many jurisdictions, I don't know if in North Carolina, but in Massachusetts, we have a volunteer lawyers project that represents families faced with eviction because of juvenile delinquency acts. And many housing court judges now will mandate a term of the eviction that if there's an agreement, a settlement agreement with respect to the eviction, the settlement agreement allows that if the child is going to be homeless, the family can come back to housing court to readdress the issue, or if the child is committed to a juvenile facility and then is re-entered, coming back into the community, that the family can come back to housing court and apply for some relief under this settlement that would have cost them eviction. So those are some more positive notes that I want to bring to you. There is change that can be done, and we're hoping that it will be done to protect children and allow them to stay with their families. Yeah.
I actually just have this one slide, but I'm going to just leave it up here, and I'll talk about it in a minute, so you don't need to focus on it right now. I just wanted to put it up there. So hi, my name's Elizabeth Frankel, and I am the staff attorney with the Immigrant Child Advocacy Project. We also teach a clinic at the University of Chicago Law School, which is where we're located. And I want to just briefly explain the work we do at the Immigrant Child Advocacy Project, because I think it will give some context to my paper and my discussion. So we serve as child advocates for unaccompanied immigrant children. A child advocate is a guardian ad litem in the immigration system. Every year, approximately 8,000 unaccompanied minors are apprehended by the Department of Homeland Security and taken into immigration custody. An unaccompanied immigrant child is a child who is, at the time of apprehension, without a parent or guardian and under the age of 18. So how does this happen? It happens in a variety of ways. In some cases, these kids are coming with family to the United States and they get separated along the journey. In a lot of cases, the kids are coming by themselves, and they're coming for a variety of reasons, to reunify with parents who are already here. A lot of kids come fleeing mistreatment in their home country. They come fleeing abuse, neglect, gang violence, war, extreme poverty. And we also see victims of human trafficking, both for labor and for sex. So these kids come for all types of reasons. And when they're apprehended, they're placed in immigration proceedings. So they're placed in removal proceedings and they're placed in immigration detention for minors. And our project is designed to provide guardian ad litem to these kids. So in our domestic child welfare system, whenever you have a child in any kind of proceeding where they face separation from parents, there's a guardian ad litem appointed to make recommendations to the judge about what's in the best interest of the child. In our immigration system, before our project, there was no comparable role, and we're actually the only organization in the country doing this work. There's also no statutory best interest standard under immigration law, so immigration judges are not actually required by statute to consider what's in the best interest of these children when making decisions. We look to international law and domestic child welfare law, and we argue that the judges should consider what's in the best interest of these children. So that's our role, and now I'll get more into my paper. So many of the kids who are apprehended immediately after crossing the border. However, an increasing percentage are apprehended internally. And what this means is that these are youth who have been living in the United States for some period of time, whether months or many years, but they come into contact with state and local law enforcement and then get transferred over into immigration custody. And my paper is focused on this subset of children, these kids who are apprehended internally. So I want to just tell you a quick story to sort of illustrate this population, and then I'll talk more about my argument. Edwin came to the United States when he was only 5 years old. He grew up in Delaware with his mother and 2 U.S. citizen siblings. When Edwin was 15 years old, he was arrested for underage drinking and was then transferred to federal immigration detention in New York. As a result, his mother, an undocumented immigrant of modest means, was unable to visit him. Edwin was adamant from the beginning that he wanted to remain in the United States so that he could live with his mother and siblings. However, he did not have an attorney to represent him in his immigration case. As months passed and Edwin remained in detention, it became more and more difficult for him. He was anxious about his future, and with time, he grew depressed. He finally gave up and went to court and told the immigration judge that he wanted to return to Mexico so that he could get out of immigration detention. Edwin had not lived in Mexico since he was 5 years old, and he had no memories of it. He planned to go live with a cousin who he had never met. He spoke only broken Spanish. Yet when Edwin appeared in immigration court, the immigration judge did not ask him a single question about where he was going or who would care for him upon his return. The judge simply granted Edwin voluntary departure, meaning he was required to return to Mexico. This deportation meant the indefinite separation of Edwin and his family. And this is a very typical profile of the kids we see who are apprehended internally. Many of these children are children who came to the United States as infants. They may not even know that they're undocumented. They've been living here their whole lives, going to school, they have family here, and they may not even remember home country. Yet for even the most minor of offenses, things like truancy, running away from home, underage drinking, jumping a subway turnstile, these youth will be picked up in the state system and in many cases transferred to immigration custody. So my paper argues that youth in the immigration system are not afforded adequate due process protections. So I want to begin by briefly explaining my argument, and then I'll spend some time backing it up. Youth in the juvenile delinquency system are afforded certain basic due process protections, and many of those protections are wholly lacking for youth in the immigration system. By way of background, the U.S. Supreme Court decided in Ray Galt in 1967, which I'm sure everyone here is familiar with since you're all juvenile justice folks, but just to tell everyone, the basic holding of that case is that youth in juvenile delinquency proceedings should be afforded certain due process protections. And the court held that even though the juvenile delinquency system is labeled civil rather than criminal, youth in that system still face a potential loss of liberty, i.e. detention. And whenever a youth faces a loss of liberty, they should be afforded certain basic protections, including the right to counsel at government expense. By contrast, in the immigration system, youth have a right to counsel, but not at government expense. So what that means is that unless a child can hire their own counsel or is lucky enough to get an attorney willing to take their case for free, they will not be represented. And there's simply not enough pro bono attorneys available and willing to take these cases. And it's very, very difficult, particularly difficult for youth with juvenile delinquency or criminal history. These cases are much more complex, they're much harder to win, they're not as appealing, and it's just a lot harder to get pro bono counsel to take these cases, so many of these kids are the ones that end up appearing in immigration court alone. And I think what makes this particularly surprising is that youth in the immigration system face the same, and in some cases even harsher consequences than youth in the juvenile justice system. They face immigration detention, and when a young person gets transferred into the immigration system, they get kids with juvenile delinquency or criminal history automatically get placed in more secure placements that really closely resemble juvenile detention. And then they also face deportation from the United States, which for many of these kids means permanent separation from their family here. So I want to briefly discuss 3 aspects of this issue. First, I want to talk about how it is that these youth end up in immigration custody. Then I'm going to talk about what immigration detention is like for children who are apprehended internally. And finally, I'm going to talk about deportation proceedings and how juvenile delinquency and criminal history can affect youth in their deportation proceedings. So now this is where the PowerPoint comes in, because I'm going to throw out a lot of acronyms, and whenever you get confused, you can just look up here. But the first is ICE. So internal law enforcement internal immigration efforts are handled by an agency within the Department of Homeland Security known as Immigration and Customs Enforcement, or ICE. ICE is specifically charged with identifying and apprehending non-citizens who are living within the United States, including youth. And in recent years, what we've seen is ICE has implemented a number of new programs aimed at identifying so-called criminal aliens, which is basically just a non-citizen who is in the custody of state and local authorities. These programs are all geared at increasing cooperation between state and local law enforcement and immigration officers. And the most common programs that you've all probably heard of are 287G and Secure Communities. So once ICE actually identifies a non-citizen who is in state or local custody, ICE will issue what's called a detainer on that child. They place a detainer on the child, and a detainer is just a request that state and local law enforcement will notify ICE at the point where the child is going to be released from immigration or from state and local custody. So I just want to focus for a minute on the point of release, because I think this is really important to think about. It's the point where the kids normally are going to go home to family. They think they're being released from the system, that instead ICE comes in and takes custody of these youth and places them in immigration detention. And because youth can be released from the juvenile detention system at a variety of different points in their proceedings, in some cases we see kids who just get picked up and charges are never pressed against them. However, if ICE identifies that that child is a non-citizen, ICE will still place a detainer and take that youth into custody. In other cases, charges may be dismissed. Again, it doesn't matter in the immigration system. And in some cases, these are kids who have already served their time in the juvenile system. So they may have served a pretty long sentence, and they think they're finally going home to their family. And instead, ICE comes in and takes those youth into custody. So once a youth enters ICE custody, there's another player that becomes involved. So the Department of Homeland Security and ICE are charged with apprehending non-citizen youth. It's the Department of Health and Human Services that is charged with the care and custody of unaccompanied minors. So ICE will generally transfer these youth over to the Department of Health and Human Services, and specifically it's the Office of Refugee Resettlement, or ORR. So I'm now going to talk a little bit about ORR custody. ORR has immigration facilities all over the country, and they have various levels of care from shelter care on up. Youth with juvenile delinquency or criminal history automatically get placed in more secure placements. And these secure placements very closely resemble juvenile detention centers, and in some cases they actually are juvenile detention centers. ORR will actually contract with state juvenile detention centers for a small number of beds for kids in immigration custody. But the reality of all these placements is the same. These are highly restrictive settings. The kids are not free to come and go. They cannot go to school in the community. They have to be escorted everywhere they go within the facility. There's often alarms all over the building, bars on the windows. And there's very few detention centers, federally run detention centers for immigrant youth. So there's actually only 8 states that even have centers, and there are very few beds in each place. So it's very common for these kids to get transferred out of state, and in many cases across the country, so really far away from their families. Now, now I'm going to talk a little bit about release from immigration detention. Kids can be released from ORR custody if they have family in the United States, and there's a process. But what's tricky about immigration detention, unlike a criminal sentence, immigration detention has no definite endpoint. So once a child enters immigration detention, they don't know when they're actually going to be released. And ORR has complete discretion to decide when a child can be released from detention. And for kids with juvenile delinquency or criminal backgrounds, it's much more difficult to be released from immigration detention. And there's a number of reasons for this, but one example, a lot of times these kids will get picked up at the point where they still have charges pending. And while there's a lot of cooperation to transfer these kids into the federal system, what we see is once they enter the federal system, there's very little communication back. So these kids may have outstanding charges and a case going on in the state system, and no one tells the judge that this child is in immigration custody, and that's why they can't show up for their hearing. And so it's very common for warrants to be issued for the child's arrest for failing to show up in court, or for the state's probation officers to issue detainers. And so if that child gets released from federal custody, they're going to be picked right back up into the state system. And so ORR won't release the kids. And then the other thing that's unique about this system, like I said, so ORR has complete discretion, and the immigration judges will not review decisions regarding release. It's something we've tried to argue to judges that they can, but we just for some reason find that they choose not to. So as a result, this agency within HHS makes all these decisions, and there's really no mechanism to appeal. And again, I come back to the fact that since so many kids have no lawyer representing them, they also have no advocate who can argue for their release. So a lot of these kids end up trapped. These kids are also in removal or deportation proceedings. So whenever a youth is placed in immigration detention, they're also placed in deportation proceedings, and they face return to their country of origin. And they have to fight a legal case in immigration court to prove their right to remain in the United States. So they have to prove that they qualify for some type of immigration relief. The grounds of immigration relief are very narrow. There's actually only one form of relief that's unique to kids, called special immigrant juvenile status. Other than special immigrant juvenile status, kids have to make the same showing as an adult. So they have to make the same showing as an adult to qualify for asylum or a trafficking visa. And for many kids, there is no relief. But what I want to talk about is how juvenile delinquency adjudications and criminal convictions can affect the chances of youth getting relief within the system. So how does the criminal offense affect kids? The answer is it depends. And it's actually a very complicated area of the law, and I'm simplifying it dramatically right now. But basically, the key is to figure out how a youth was charged and adjudicated. So in general, kids can be charged and adjudicated in one of two ways, either as an adult in adult criminal court or as a juvenile delinquent in family court. Some states have hybrid mechanisms, but I won't get into that. So if a youth is charged and convicted of a crime in adult criminal court, that youth will be subject to the same grounds of removal as any adult under the Immigration and Nationality Act. Under the INA, as was referred to earlier with the discussion of Padilla, a criminal conviction for a broad range of offenses will render an individual subject to mandatory deportation and lifetime or long-time bars to ever returning to the United States. And what's so harsh is that judges actually lack discretion to ameliorate these harsh consequences. So once a conviction-based ground of removal is triggered, it generally means automatic deportation for adults and youth who are charged as adults, charged and convicted. And within the juvenile justice system, the trend has been to charge more and more kids as adults, and the consequences for non-citizen youth are very, very serious. Now, if a youth is charged and adjudicated as a juvenile delinquent in family court, that child will not be subject to the mandatory conviction-based grounds of removal under the INA. However, a juvenile delinquency adjudication can still also have very serious consequences, and there are two main reasons. One, under the INA, some forms of removal are actually triggered by conduct alone, so you don't need a criminal conviction. And for those, a juvenile delinquency adjudication can serve as evidence of the underlying conduct. But the other most common way that juvenile delinquency can affect kids in their deportation proceedings is because all forms of immigration relief are considered a benefit and not a right. And so what this means is even if a child proves that they've met the standard for asylum, a judge can always decide to deny that child asylum for any reason at all. And juvenile delinquency is commonly a reason that judges will deny relief to kids. So it doesn't matter that that child faces potential serious harm in their country of origin. The fact that they have a juvenile delinquency adjudication will mean a denial, and then that child is deported. So as you've heard today, in March of 2010, the U.S. Supreme Court decided Padilla versus Kentucky. And Padilla held that pursuant to the Sixth Amendment right to effective assistance of counsel, criminal defense attorneys have an affirmative obligation to inform adults and youth of the immigration consequences attendant to a guilty plea. And Padilla is a really important decision, I think, in large part because it recognized how serious the consequence of deportation is for so many non-citizens. And the court recognized that for many, the idea that they might be deported is so much worse than having to serve some time in jail, that really the idea of being deported and permanently separated from family is the harshest consequence of a conviction. But what I want to talk about is what Padilla really means for a lot of these kids in reality. Because so many kids leave the criminal defense system and enter the immigration system and are not provided counsel, once they enter the immigration system, I feel that Padilla, for many kids, becomes meaningless. It just doesn't get you all the way, because without an attorney in the immigration context to actually make the arguments to the court and file petitions on the child's behalf, these kids are just going to end up being deported anyway. And I think it's important for all children to have an attorney in immigration proceedings, but I think it's particularly important for this subset of children for a few reasons. First, as I alluded to earlier, these are kids that tend to get trapped in secure detention for really long periods of time. We've seen kids who serve long sentences in the juvenile justice system, and then they get transferred to immigration system, and they serve double their original sentence because they're stuck in immigration detention. These are also really tough cases, and again, as I referenced earlier, it's really hard to find pro bono attorneys to take these cases. And yet these are the cases where you really need attorneys. We need attorneys to make arguments about rehabilitation and ties to the community, and why the different grounds under the INA should not, apply to these kids. And finally, there's often a lot of safe repatriation concerns in these cases because these are kids who haven't necessarily lived in their country of origin for a long time, and they may not know anyone there. So they often will not have family to care for them, and yet they face deportation, and essentially they face homelessness. And I think the rationales that were given by the court in Galt to justify a right to counsel for kids in the juvenile delinquency system would apply equally to immigrant youth. First of all, these kids obviously face a loss of liberty, and the fact that immigration is also considered civil, like the juvenile delinquency system, shouldn't be a justification. I mean, the court in Galt rejected that distinction and found that the reality is detention, it's confinement, and kids experience all forms of detention as punishment, and it doesn't matter how you label it. And then this loss of liberty is further compounded by the fact that they essentially face exile from the United States. So I just want to briefly mention a recent decision that came out because it's an exciting decision in the immigration world. It's a decision that came out by the U.S. District Court for the Southern District of California, and the judge in that case was deciding that the plaintiffs are a class of mentally incompetent, non-citizen adults who were in immigration detention and in removal proceedings and did not have counsel. And the court granted a preliminary injunction enjoining the Department of Justice from pursuing removal proceedings against those adults until they were granted qualified representation, meaning either a pro bono attorney or an attorney at government expense. And I just want to mention one of the arguments that was made by the attorneys in that case, because I think it's a great argument and would apply equally to kids. They argued that the due process right to counsel is analogous to the due process right to a translator in immigration proceedings. And the courts have held that there is a due process right to a translator in immigration proceedings because without a translator, it's impossible for an individual to really have a full and fair hearing under the law. And I think it's equally true that for these kids, when they're in court without an attorney, it's basically like they're listening to their case in another language. I mean, it's all legalese, it's totally confusing. The judges do explain that the kids have a right to put witnesses on the witness stand and present evidence, but the reality is these kids can't do that. So I think that, it's clear the courts have repeatedly recognized that when individuals face a loss of liberty, they should be provided certain protections. And without a right to court-appointed counsel, immigrant youth lack one of the most fundamental due process protections under our Constitution. That's all.
Would you all like to take questions for a little bit? Okay, let's do that. I talked to the people that are recording this, and they said that they could give us until 3:15 if we absolutely need it, so.
Now you tell
Got a
them.
few extra minutes here. So, yeah. Does anyone have any questions that starts off with? How about in the back?
I have a 17-year-old friend who fits the description that you just laid forth, who just found out a couple of months ago that he's not an American citizen. His family came over, they had a visa, it expired, they did nothing about it. He's a good kid, wants to go to college, wants a career, he doesn't know what to do.
Yeah, I mean, those are really tough cases because the child's been here for a long time. He's not in removal proceedings, I'm assuming. I would advise him to go talk to an immigration attorney and be screened to see if there might be some way that he qualifies for some type of relief. I mean, the most common grounds for people who have been living here, if you're a victim of a crime at some point, you can qualify for a U visa. Generally, kids who are victims of trauma can qualify. So if you were a victim of abuse or neglect in the past, you'd qualify for special immigrant juvenile status. This sounds like he was a DREAM Act kid, and unfortunately, the DREAM Act did not pass. So a lot of those youth are youth that are going to end up sort of, in this limbo where they could get picked up at any time and they're in danger of being deported at any time. But as long as they can stay under the radar, then they can continue living here. I mean, I think that's not obviously a great answer, but I would recommend trying to seek out counsel. And if you want, we can talk after and I can give you recommendations of people that might be good to talk to. Yeah.
Can we go here and then here?
Me?
Yes, ma'am.
Oh, okay. On the collateral consequences of delinquency, I appreciate your passion and your study of this. I haven't given this matter any thought, but I do come from Detroit. And one of the things that has become very evident is if you don't have some kind of policy to kick out the people that are the juveniles that are 10 or 11 years old, that they are committing murder, they are drug dealers making $1,000 a day, they set fire in order to get into a gang, you have to do something really, really bad, like setting a house on fire or killing somebody. And all of this leads to a situation of where eventually that public housing unit is no longer habitable. It becomes condemned, and all the families are thrown out, and everybody is homeless. So I would say on the first strike policy, or if you want a 3-strike policy, I think it should depend on the type of crime that's being committed, because a drug deal may not sound significant, but boy, it sure as heck escalates into really bad things.
Well, we didn't think that the policy should be completely removed so that public housing authorities could never take action when you had a terribly disruptive child in the family. But the way the policy exists now, it's a one-size-fits-all policy with an incentive to exercise absolutely no discretion at all. And even a 10-year-old kid who does very terrible things would be treated in the juvenile court system as a problem to be addressed as opposed to a problem to be banished. And it may be that when that child comes out of a period of detention, having received the services that he needs to change, what do we do with him? I mean, he's not going to go away. And if you made his family homeless in the meantime, putting him out on the street or giving him back to a homeless family, removes him from the public housing agency, but puts him someplace else. So I think my response in any event, I don't know if Wendy's would be different, to what you proposed, is that we want the incentives to apply the policy mindlessly in each and every case removed, and to have the juvenile correction authorities, the juvenile court, and the housing authorities learn what each of those three parts of the triangle are doing, so that they can all make more informed decisions about how to deal with kids.
Absolutely, I agree with David. I think that housing authorities should be looking at the nature of the offense, the role that the child played in the commission of the offense, and what has happened to the child after the child has been arraigned in the juvenile court. It's highly likely, in really serious cases that you're outlining, that the child is not going to be released to the community. The child's going to be put into either a detention facility, or in your hypothetical, a 10-year-old who clearly has psychiatric problems. They're going to put that child into some sort of specialized locked child hospitalization unit. Because I think that it's fair to say your concerns are the concerns. The community has to be able to balance the community safety concerns with the individual child's. But as David says, it shouldn't be just a random one strike you're out. It should allow the authorities to look behind the charges and get more information so that they can make a better decision about the eviction process. But a good point, a really good point.
Thank you. This dovetails well. I also had a brief comment and a question for Wendy and David. The comment is that, I mean, the research is clear that policies like these, if anything, make crime worse, not better. And to me, this doesn't seem about crime control. I think it's the symbolic labeling of the deserving versus undeserving poor. It's no coincidence that this happened in 1996 with Newt Gingrich's revolution coming up and Clinton trying to defend himself by going on board and saying we're no longer giving public monies to the undeserving poor, and this is one label of it. But my real question for you is whether or not there's been any look, has anybody looked at displacement effects of this in terms, I mean, it's clear some of the effects that you've discussed, but on a large scale level, city level, have there been noticeable homelessness increases that can be attributed to this, or has the demographics of the housing unit populations changed as one group gets evicted? Are higher income people moving in? Or, yeah, I mean, slightly, obviously, below the line, but have there been displacement effects that have been?
Well, one of the frustrating things about trying to write in this area is that there is very little systematic investigation of the phenomenon. Housing authorities do individually report the number of evictions, but HUD doesn't correlate that in any way or aggregate it, and they don't release the information. And nobody reports how many families voluntarily choose to banish their kids. So it's hard to get a sense of the magnitude of the problem, because a lot of it simply is never documented anywhere. No one ever looks at it. And in terms of even documenting the effect of what you can measure, no one's done any control studies that I was able to find that showed any time series effect or any comparative effect in a housing project, even, like a before and after, to show that crime rates have gone down as a result.
When these types of strategies have been applied in other community or different contexts, they've been shown to backfire, is what I was referring to.
Yeah, and I just don't know about it.
Actually, in Boston, we have one example, and that's the Columbia Point or Harbor Point housing complex, which, when it switched from Columbia Point and was rebuilt into Harbor Point, had a static group of 300 families, of which now 48 are left, thanks to these policies. And the people who've replaced them are almost uniformly Latino or college students. And the Public Housing Authority manager there is Latino and outspoken about his dislike of black folks. And it's to be, an obvious following. And that brings up other related questions about the use of private security in public housing developments to accomplish these goals when there's no oversight of private security in those developments.
We don't have the data on this, but we did unearthed some data that came to us from the Wilder Research Center in Minnesota. You may be familiar with them, that talk about homelessness, the percentage of homelessness of youth ages 10 to 17 who had been in juvenile correctional facilities and then were released, and the ultimate homelessness. So we do have that information. But it's, as David said, it's like trying to hold air. We just can't do it. Can't find it yet. Maybe that's another study for you, Aaron.
You're talking about something kind of after the fact. What about looking at it from before? Is there anything at all for these parents who have a child who's drifting toward bad peer pressure to keep from the things happening, the horror stories that you're talking about? Is there
Well,
something-
if you're in a public housing project and you have a kid who's drifting toward drug use, I'd be thinking twice about trying to take advantage of anything that might come to the attention of the manager of the housing project, because the lease term is written so that it doesn't require a child to be convicted, doesn't require a child to be charged, it doesn't require a child to even be arrested. It just requires the child to engage in that behavior. And so it can be a two-edged sword. And it's ironic because the government also had, at one point, they're not really funding it much anymore, a program to give housing authorities money to set up drug treatment facilities and programs to support families like that within the housing authority. But then it, has another program that rewards housing authorities for evicting people who have a family member who is in fact using or selling drugs.
It seems that your list should add, as another point, parents that try to keep their children straight should not be evicted.
Yeah, well, I did run across an interesting case from Pennsylvania where a mother had a son who was 14 who was found delinquent for using drugs, and the son was committed to a juvenile detention facility, and the housing authority manager learned about it, and so the mother had to agree not to allow the son to come back in. Well, when the son came time to be evaluated by the juvenile detention authorities, they said, well, we're only going to release you if we can monitor you. Otherwise, we're not going to release you. So the mother said, fine, he can come back to my house. The probation officer can call my home. And as soon as the housing authority found out about that, they evicted the mother. So, it puts you in a very difficult situation as a parent.
And also, if you, as a parent, are trying to access services in many jurisdictions, those services are offered through the family court or the juvenile court as status offenders, runaways, stubborn child. Truancy actually comes under that rubric, at least in our jurisdiction. And that's a way that parents can get access to some social services. But again, you run the risk of having that information somehow getting to a public housing authority, and you're looking at potential eviction. Higher number.
I think, Mr. Howard, are you planning on opening up for discussion in your closing remarks? Or, so we can take one more question now, and I think Mr. Howard is going to open up the floor for generalized comments as well during his section. So is there anyone else that would like to ask our authors? All right. Well, Mr. Keith Howard is a staff attorney with Legal Aid of North Carolina, where he works for a special project called the Advocates for Children's Services. With other attorneys across the state, Mr. Howard works to ensure that at-risk and court-involved children receive medical, psychiatric, special education, foster, and adoption services that are promised to them by law. Primarily, Mr. Howard represents